Hi, and welcome to this edition of Beyond the Gavel. This is somewhere where we explore the intersection between law, medicine, and forensic science with leading experts. My name is Rodney Peyton, and I'm your host for today. And I have the privilege of introducing a distinguished guest whose contribution to healthcare law, particularly, has significantly impacted the legal landscape in Northern Ireland. Now, Paddy Mullarkey is a partner and head of healthcare department at O'Reilly Stewart Solicitors in Belfast. He, like me, has well over two decades of experience, and he specializes in clinical negligence litigation, particularly cases involving birth trauma, cerebral palsy, catastrophic injuries. And he's been instrumental in securing multi-million pound settlements for his clients when this demonstrates his unwavering commitment to justice and patient advocacy. He's also recognised as a Band 1 practitioner by Chambers and Partners in London, and he's lauded for his meticulous approach and the dedication to his clients. He also serves as chairman of the Law Society Clinical Negligence Practitioners Group and is a CEDR accredited mediator, and this reflects his versatility in both litigation and alternative dispute resolution. So today we're going to look into Patrick's extensive experience in clinical negligence law, look at what the new trends are and the challenges of handling complex medical cases. So Patrick, welcome to Beyond the Gavel.
Thanks very much, Rodney. Delighted to be here.
As always, it's lovely to meet you, Paddy. It's just we meet so seldomly, but coming on this works very well for all of us. Now,
Absolutely.
Paddy, you have been at the forefront really in developments of law, and you also keep very much up to date. What trends have you noticed, for instance, in looking at consent law? We had the high mark you pointed out of Montgomery. What do you feel is happening now to consent in the UK and Ireland?
Absolutely, Rodney. The Supreme Court in the Montgomery decision back in 2015, that was a watershed moment certainly for the victims of medical accidents, where eventually the idea of the patient's informed consent was explicitly recognised, and not only recognised but vindicated by the court at that time. And that was an interesting point. I think that lead judgment in that, which was written jointly between the Lords Reid and Kerr, Lord Kerr being a former Lord Chief Justice of Northern Ireland, these were two individuals who recognised the rights-based entitlement of today's modern patient, essentially a consumer of service, to have information provided to them in a meaningful way to allow them to make a proper decision. And if that right was interfered with, then they were entitled to have that right vindicated in judgment and in damages. And that changed the landscape of litigation for us as clinical negligence lawyers, because before that point, you were relying upon scraps of judgments, which were not the ratio of decisions, such as in situa and so on, to say that there needed to be a proper discussion. At last, we had it down in clear black and white from the highest court in the land to say that this is what you have to do. But that's changed over the course of the last number of years. And we have another Supreme Court decision in recent years, which has reintroduced the idea of bolum negligence back into that consideration of the consent process. And what that says is that Montgomery essentially said that material risk had to be disclosed to a patient. And in order to get to that point of understanding what material risk was, there needed to be a dialogue between the patient and the doctor to work out what was material to that patient, what was important to them, because what might be material to one patient may not be to another. And the more recent decisions, in particular the consent decision of the Supreme Court, says that a doctor is essentially allowed to exercise a reasonable bolum type appreciation as to what is a material risk or what is reasonable to disclose. So there could be a hierarchy of particular risks attaching to a particular procedure, ranging from 5% risk of occurrence right down to 0.01% of a risk. And a doctor is now entitled, as part of a professional review, to decide not to disclose that lower risk if it's not reasonable from a bolum perspective to do so.
We've always been told as doctors not to put people off. That was one of our upbringings. Don't put people off surgery. So you can see that. And it's interesting, Australian law never went that way. It's common law still there. And they did not go that far. So it's interesting how the UK and other jurisdictions are putting into line. And also there's the talk about secondary victims. There's changes in that law as well.
Yeah, there has been, Rodney, there's been fairly significant change in relation to it. Up until January 20, I routinely litigated on behalf of the next of kin of patients who, for example, had died in the course of medical care.
Yeah.
Not only in respect of the claims for dependency and loss and damage to the estate, but also in relation to the specific loss occasioned to them by virtue of the death of a loved one. So they would frequently present with a mental health reaction, a psychiatric upset, an anxiety disorder, or an adjustment disorder by reason of the death. And that was, in my experience and in the experience of many of my colleagues, routinely compensated and awarded by a court. So we would have been settling cases on that basis in a regular way. In January 2024, the Supreme Court, in a case called Paul against Wolverhampton Health Authority, essentially ruled out any secondary victim claims, save for in exceptional circumstances. What the court said in relation to that is, firstly, that a doctor doesn't owe a duty of care to anybody other than the person who is undergoing care. And secondly, that a medical accident is not an accident for the purposes of seeking compensation for psychiatric harm. So it's not an external event or incident which is witnessed, which is caused by violence or otherwise. This is something which is the natural progression of a disease or whatever. They went on to say, from a policy point of view, that they didn't think that society was ready for that duty to be imposed upon doctors. And that represented a fundamental shift in practice for practitioners in relation to this type of claim. And that's a big change now, because
What does that mean with, you've got personal injury law, traffic accidents, people injured in the street, and trauma, riot, whatever, and then medical negligence? Is there a difference between those two now? Has that been polarized?
Yes, it's been sundered in relation to Rodney. So what they say is essentially that if you die, or if a patient dies in a shocking circumstance by virtue of poor care by a doctor, and you witness that death and that causes you upset, then unless you can prove this to be an exceptional case, you will not be compensated for the loss that you experience by virtue of that. And that is a big change. And what I would say is that it's differently treated within different parts of the UK. In Scotland, by virtue of their fatal accidents legislation, the exact type of loss, the distress that somebody experiences, the grief that they experience by virtue of the death is recognised by that statute. But elsewhere in the United Kingdom, Northern Ireland, Wales and England, that's not recognised. So in my experience, there are now people who are going uncompensated in respect of very genuine loss that's afflicted them. And I see that in cases where somebody, an expectant father present at a birth, which goes wrong, and the child is stillborn at the time of delivery, is now being told that you have no right, you've no right to compensation in relation to that. And that's a big change, and it will be fought and it will be resisted. And people are looking to see where liability might arise under other areas.
Yeah, and get a case in that. So
Yeah.
that's so. Let's move on. And that's the stuff that you're really keeping up to date, and part of your work with the Practitioner Society, Clinical Negligence Practitioners, is about keeping people up to date.
Yeah.
How do you find this is working? I've done a lot of CPD for lawyers, and how do you find this is working generally? Are lawyers keeping up to date, or is it a mixed bag? Or
I think that we set up the Law Society Clinical Negligence Practitioners Group of the Law Society, set it up back in 2018 in response to a view that was being expressed by, amongst others, the judiciary, that practitioners were pitching up in front of them without the first notion of how to litigate these cases. And they wanted to be in a position to educate the people who are doing this work to make sure that it's done correctly. And so that grouping was set up with that aim, amongst other things, to make sure that practitioners who do this work are given regular continuing professional development, which allows them to understand both the procedure and the practice and the theory of what they're doing. We've been doing that now for 7 years in relation to it.
How's it turning out?
I think it's turning out well. We get good attendance in respect of the CPD that we do. We have a good program that we run. We run it 4 times a year with a conference at the end of the year, half day, now extending probably up to about a day. And we get good attendance at that. That's always sold out. We've about 160, 170 members in Northern Ireland. And whilst they're not all massively active in the sense that they would be at every event, we generally get very good numbers engaging. We get good numbers engaging with any surveys that we do to talk about practice. And I tend to find in this area, people are vocationally committed to it, so they tend to get involved, and they like to get involved. So it works very well from that perspective. There's a world of difference, Rodney.
You get staff then that are like that. You've hit a very good point. The people tend to be very dedicated to that. How do you find young people coming in? Are they dedicated, or they don't know where they're going, or how do you work with employing people and bringing people into your firm? Because O'Reilly Stewart's a massive firm.
I think we'd be described as SME in Northern Ireland terms. We're a good size for a law firm. It's changed completely, Rodney, again, in the time that I've been doing this. So I'm just going to flick this light on again here for a moment. There we go. It's changed completely in the time that we've been doing this. I started off, you were cast out into the wilderness and left to find your own path. And people ended up in this work by accident as much as design in that. Now, clinical negligence, medical negligence is studied at undergraduate level. So you can do it as part of your degree as a bit. And if you're interested in that area of work, you can. And people that we see do it at that point, or their interest is peaked at that point. You can do it then in your professional qualification at the Institute of Professional Legal Studies. It's a compulsory part of the course. I'm going up there at the end of next month to do the clinical negligence module that I've lectured on for the last 5 years in that place. And that's taken very actively and very seriously in relation to it. And what I find then is that people who want to work in this area start pointing themselves in that direction. So they're enthused by their undergraduate course, something about that work that they like, interest in. They do it as part of their postgraduate professional qualification. That again does it. And I say to the people who are doing that, they'll approach me at the end of it and say, look, I'm really interested in doing this work. What should I do? And I'll say, when you get qualified, join our group. So you're getting your CPD in relation to it. Involve yourself in the area that's going on. So go to CPD, go to the Medical Legal Society. It's a separate one. And they do slightly more esoteric talks given by doctors about an area of practice, or given by a lawyer about historic cases or otherwise. But get yourself involved. Get into the forum where this is happening. Make yourself known to practitioners. Make yourself known to the judiciary when you come across them. Make yourself known to the lawyers. Know the law. So the basic currency in relation to this is know the law. If you don't know the law, you're not going to get anywhere here. And I don't mean know the head note or know the ratio or know what's written on a website in relation to it. Read the judgment. Read the previous judgments that gave rise to that judgment. So know the evolution of the issue in respect to consent. Know that Bolam starts it all off, and then you've got a development that goes through Blytho and Sidaway and up to Montgomery and goes on to McCulloch and all of those other cases, so that you understand the nature of that. Have a curiosity. When you read about something by procedure, or when you're consulted in respect to something in relation to it, go and read about it. Read about what happened, what the expectation is, and do that. So I think there's a balance, Rodney, between, in terms of being present, being in the area of work, showing an enthusiasm in relation to it, and then doing the work when you're there, and do that. And what I would also say is that to get to that point, medical negligence is litigation. And litigation is about an adversarial system. You are having a dispute which has been resolved by an adversarial system. Now, there are other ways of doing it, by alternative dispute resolution or otherwise, but ultimately you have to know how to run a case. And you don't learn medical negligence litigation solely by running medical negligence litigation. You learn it by doing road traffic accidents, and you learn it by doing regulatory matters, and you learn it by going down and sitting in a criminal court and having a look at how people get on in the course of examinations, in the course of giving evidence, because this is what this is about at the end of the day. This is about what passes for truth within a court, and you have to understand where that truth is. and you have to know how people react under pressure. You have to know how they answer questions. You have to know how a case can go south very quickly if a witness doesn't give the right answer. And all of that has to be built into your arsenal of available tactics or weapons or otherwise in terms of what you're doing from it. Because
So that
you need
brings me to the point then. You're really hitting on it then. That's what you expect them to do. So when you're seeing somebody in front of you, those are the sort of things you're looking for. And one of the things you also brought up there was relationships. It's not about who you know when you're looking for a job. It's about who knows you. And they need to know you. You're branded. They need to know what do people say about you when you're not there. When they come to you, do you know them? So this is a good lesson for people coming through. And it is a matter of making sure that you are known and making sure that those people to whom you wish to work, that somehow you add value to them first and they come back to you, not just saying, here's my CV, take me. You're being biased if you don't.
Well, the vast majority of people that we do employ in relation to this, we've known them before, Rodney. Like they've introduced themselves, they've made themselves known. And by the time we then get into a competitive process in terms of appointment, be it interview or otherwise, we're going to see CVs popping up of people that we've spoken to previously. Now, in any process in which you're involved, you've got to be fair. You've got to appoint the best candidate for the job. But the best candidate
for the job's not necessarily the person who knows the work. You expect them to. It's about culture, isn't it? It's about whether they're going to fit with your culture. Somebody said if you have a good lawn and you put a weed in it, it'll take over the lawn. And you, in your firm, have to look after the culture of your firm. And the people who work for you have got to fill in that culture. And you want to know that in advance. You don't want to bring them in and then find out they're weeds.
Yeah, even you want to know if you get somebody in who wants to do this work, if you get somebody in who is vocationally committed to doing this work, you are more than 50% along the way of having a great lawyer in relation to that. Because somebody who's self-motivating, who's self-starting, who demonstrates that willingness to be self-starting in terms of their engagement. It doesn't have to be in medicine, it could be anything else that they do, as long as they are getting up and getting on it. Then in those circumstances, that is always going to be a matter of encouragement for any employer that ever sees you.
And then that would come then, how do you help them from your extensive experience to select those cases which are viable? A lot of people have complaints. There are many complaints, but they're not necessarily a medical negligence case and one that has a reasonable chance of success. So how do you start helping people to understand what are the keys to viability of a case that you help these young people to learn?
Yeah, that's the magic bullet in respect to this work, Rodney. Clinical negligence work and finding clinical negligence cases that are actionable is a difficult job in our experience. And you'll know yourself through the screening that you do as part of your advices that the rate of attrition in relation to initial contact to the point of going ahead with the case is huge. And I would say in our experience, if you are taking on 5% of the cases that approach you in terms of looking for advice, then it's as much as that. We run a business. If you're going to run a business which is going to be viable and is going to continue, you have to be able to identify these cases. The reason why other firms don't do this work is because in a lot of cases, they've taken on one or two, they've run them for a long period of time, and they've got to a point where they've had to drop their hands. They've got a big set of costs off the back end of it. They've spent money on reports and it's not going anywhere, and they think, I'm never doing this again. So we do spend a lot of time and we put a lot of experience into the triaging of medical negligence cases. So we have a point of contact.
See, if you do 100, 5% is 5. If you do 2, 5, what's 5%? And you're right, smaller firms trying to take this on without any background at all. We know, you and I both know, the strategic importance of proper screening, the strategic importance of having that high level look to see whether a thing is viable from duty breach and or consequential damage. We know that, and we're long in the people coming in that do 2 or 3 cases, they're up a gum tree because when you turn around, I turn around even early and said, look, this is not valid for the following reasons.
Yeah.
Then they go, wow, but those are the only cases I've got. So,
Yeah.
you know what I mean? Just to take a case on. Justice isn't served by taking on every case, is it? It's about
No.
taking the right case and then having the power to fight for that right case, which is
Yeah.
something I know that O'Reilly Stewart is very good at, and you're head of that
Yeah.
litigation department because your reputation precedes you. So, if you were to give advice to someone who was running a medical legal practice, and especially in those complex cases, what one piece of advice would you give them, maybe right at the start or when they're running a case, to help them get those successful outcomes that you have?
It's got to be about case selection, Rodney. It has to be. You've got to select the right case, and to get to that point, that's a combination of various factors. So first of all, you got to understand what the case is about. And look, I lecture at the Institute of Professional Legal Studies, as I say, and I say to the prospective solicitors and trainee barristers at that point, at the start of this process, the embarkation point is a proper complaints procedure. Get your client to raise a complaint with the healthcare provider and get a response. It is rare that you're going to get a response back, which is the two hands in the air saying, we're terribly sorry about what went wrong, because you won't get that in the vast majority of cases. But what you will get is a narrative of the care that was provided.
A
You
good
will get,
chronology.
yeah, you'll get, if they think that they can defend it, an explanation as to why they think that the care was fair, because people are very quick to put a explanation for the care being provided if they think that what they did was reasonable. And that will allow you then to look at it in the context of the discussion that you've had with the client and say, actually, do you know what? That's probably fair. Or on occasions, in 5% of the cases, you're going to look at it and say, actually, there's something off there. That explanation doesn't ring true. You'll see it on the basis, for example, somebody goes in for an operation, keyhole surgery. They come out, seem to be doing okay. Day two, day one, they're not doing the best. They do a blood test, and that blood test says that their CRP has climbed a X point. And they do another blood test the day after, and the CRP is twice as high as it was before. And there's no explanation given about the significance of that. There's no account taken of it. Nobody says, maybe we should have looked at that and done something different. So there are pointers in respect of these responses that you get back, Rodney, which raise red flags, which as an experienced practitioner, you will recognize that. And this is the point that I'd make, is that if you're going to work in a team which does this work, you do need to have people within that team who are going to look at it and say, there's something off here, because junior solicitors without the experience in relation to having litigated these cases, it's not going to work. And I'm always struck by the fact that we had a guy over talking to us who's an ED practitioner in Manchester. And he was over talking about treatment and diagnosis of neurological injury and so on within the ED department. And he says that in his work, he doesn't see any patients at all. He sits at a computer screen in the middle of the department and he reads the reports which are taken from the triaging nurses and the first doctors that see the patient. And he says, by the way, you should be looking for this. So the benefit of that experience is being applied for everybody within the place. And that's the same, in my view, in respect to this work as well. It takes...
It's not absolutely true. You're pointing out it's not just what you know from your professional point of view, it's the experience on top of what you know.
Yeah.
In other words, you start to know what you didn't know. We call
Yeah.
them teenagers of surgery, and they're up to the age of 40 when they still think they know everything.
Yeah.
After 40, you begin to realize maybe you don't. And the older the tooth you get, there are many more ways of looking at it. And
Yeah.
you exemplify that. And obviously, you're helping that in your people. This has been a wonderful podcast. I hope you've enjoyed it half as much as I have. And I look very much forward to working with you again in the future.
That's great, Rodney. Thanks very much. Always enjoy speaking to you.